have your family to refresh their link. It should be live now. Do you see it?
Yep, got it.
Okay, great. It's coming out. Okay, let me do it.
It started right up.
Okay. This is from all of y'all. This is the get back, guys. I got you. Thank you all so much.
Do the judge allow them to have mask off or on?
This is an optional mask.
Okay, it's optional.
Mhm.
Just for,
And you just pour under water.
just for.
Mhm. This is so pretty.
Which is the
Thank
first.
you.
Hey, I
Frame
didn't
that.
wrap it earlier.
Okay, let me go get him.
And we are starting the corporation.
We're gonna deal with divorce while I find out what divorce is, and then we're gonna handle.
Divorce first.
Mhm. Cause I think this one is gonna take a little bit longer.
Thank you.
This one is gonna take a matter of minutes.
She said divorce Jones.
I don't know, she said Tavares or yes.
Just want to know what position, I see it. Jones, but also know that you didn't have to use the. Divorce first. I don't like. to use the-
Yeah, those are the only, yes. I know what you're saying.
I thought to say something in the middle in the beginning. Okay, so there's a divorce person and a divorce Jones.
Only Tavares is on.
They must be
here.
handling-
Tavares isn't actually here yet.
The 15 SC 136825,
That's. one.
because that's the indicted case that would be reading, and the other
Okay.
ones, so it has to be that one.
Okay, thank you.
You're welcome. Yep. Oh, thank you. Yeah, we'll turn it in at the right time.
was already like. Yeah. So then payment. You do it, take it back. Maybe it's me up to the end. It could be big. You let out. Yeah, I mean, how much it is. He's slamming it up here.
So this is Danielle Aaron.
You might be going to.
Thank you.
Wow.
Okay, I'm rolling.
While you do that, I'm gonna open up this email to start.
Okay. You want to try it again, Officer Montgomery?
I got it. Thank you.
It's the same one,
Huh?
same one as this one.
Oh, yeah, same one. Oh, you took them out.
I did.
Got it.
Well, we now come to order.
Please be seated. It's the mask optional courtroom. All right, are we ready with the plea?
Judge, we want to handle the, help me out.
Resentencing?
The resentencing judge in front of you is position,
Is it ready?
hold on, hold on,
She gotta let me
I
in.
gotta admit you.
Is this where we're on the Hurston case?
Yes.
I wanted to divorce by accident.
Yes. What's the noise?
It is nice.
Hold on. You're gonna disconnect him from the audio. It's still doing it? Hold on. Okay,
We're
I
good?
think we're ready.
All right, I have the defendant Javorius Hurston's motion to vacate the sentence and re-sentence.
Yes, Your Honor. Leah Abbasi here for Javoris Hurston.
Amy Maxwell here from the District Attorney's Office.
All right, so we've agreed on this?
Yes,
Yes, we
Your
have.
Okay, the agreed sentence was 20 years to serve on voluntary, 5 years of probation, possession of a weapon during the commission of a crime, a total of 25 years to serve, 20 in custody. And the sentence was entered inappropriately. And so we're going to vacate the previous sentence and re-sentence to the 25 years to serve 20. Okay, credit for time served. Can somebody submit me an order, please?
Your Honor,
Yeah.
go ahead.
Yes.
Ms. Maxwell.
Actually, Your Honor, we have agreed to a slight sentence reduction in this case.
Okay,
It would be 20 on count 1, it'll be 20 to serve 15. Count 2 will be dismissed. Count 3 will merge with count 1. And count 4, which is possession of firearm during the commission of a felony, will be 5 years consecutive to count 1 suspended.
okay, that sentence you just enunciated and agreed to by defense counsel is hereby made the order of the court. Okay, so somebody please submit me an order.
Judge, I'll have to I'll have to do a new sentence.
All right, Ms. Woods will do it. Ms. Woods will do it. Okay?
Thank you, Ms.
Thank
All right,
Williams.
good to
Thank
see
you, Your Honor.
everybody.
All right,
Yeah.
thank you.
Thank you.
We have one more case, Judge, on there. Tavoris Jones, I'm looking for.
If that's it for y'all, y'all are excused.
I think Ms. Maxwell has one more case, is that correct?
I am here.
Okay. And Cody, you're here. And is Mr. Jones here?
Yeah, ma'am.
Okay, great. So
All right, where are we now?
the next case.
Tavoris Jones, what are we doing here?
Your Honor, we have a joint motion, extraordinary motion for a new trial. And we would like for you to grant that motion, and we would like to take a new plea to this, in this case.
All right, do you want to do that plea today?
Yes, we are ready.
Okay, so we're gonna do a consent granting of a motion for new trial. So
Yes.
somebody please send that to me, and let's proceed as Mr. Jones is where?
Yes, Your Honor. And Judge, my name is Cody Young. I'm here on behalf of Mr. Jones. Judge, I sent over the proposed consent order about maybe 15, 20 minutes ago to Ms. Woods, so I
Okay.
doubt she's had an
I'll
opportunity.
enter that by agreement. And what is
Thank
the
you,
new sentence going to be, Ms. Maxwell?
Okay, so the new sentence is, for count one, which is armed robbery, it'll be 20 to serve 15. Count two, which is possession of a firearm during the commission of a felony, will be 5 years consecutive to count one, suspended. Count three, theft by receiving stolen property, will be 5 years concurrent with count one. Count four is possession of a firearm by a convicted felon. That's 5 years consecutive to count two, suspended. Count five is also possession of a firearm by a convicted felon. That's going to merge into count four. And count six, obstruction of a law enforcement officer, will be 12 months concurrent with count one, suspended.
And what is the credit date?
The credit date is,
Your
I
Honor, I
just wrote
believe
that
that's
down.
December 30th, 2013.
that is correct.
And what is the current sentence that we're vacating?
Well, I don't actually have that right this second, sorry.
I have it pulled up, Ms.
Okay.
Maxwell, if you would like.
Thank Yes, please.
Sure. Your Honor, count one, armed robbery, the current sentence is 20 years to serve 18 years, balance of 2 years probated. Count two, possession of a firearm or knife during the commission of a felony, right now is currently 5 years suspended. Count three, theft by receiving stolen property, 5 years to serve, and that would be concurrent to count one. Count four, possession of a firearm by a convicted felon, that's 5 years to serve, concurrent with count one. Count five merges with count four, and count six, obstruction of law enforcement officers, 12 months suspended, concurrent with count one.
Okay, so we're going to sign the order granting the new trial. And then let's do the plea now. If you'll proceed, please, Ms. Maxwell.
All right. Your Honor, would you like me to ask the questions about the Zoom questions?
Please.
Okay. All right. Your Honor, we will be proceeding under indictment number 14 SC 124061. Mr. Jones, would you raise your right hand, please? Do you swear or affirm that the testimony you shall give in this matter currently before the court shall be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
All right, thank you. Mr. Young, have you had a chance to discuss today's proceedings with your client, Tavares Jones?
Yes, ma'am, I have.
Does your client fully understand that he will be appearing via Zoom and will not be present in court?
Yes, to the
in the
best of my
courtroom.
knowledge, yes.
Okay. Did you obtain a waiver, written or verbal?
Verbal.
Okay. And do you waive an original signature on the indictment and authorize the court to sign the indictment on your behalf?
We do so waive.
Your Honor, the state also authorizes you to sign.
Okay, Ms. Woods can do that on behalf of the court.
All right. Mr. Jones, have you discussed today's proceeding with your attorney?
Yes, ma'am.
Has your attorney explained to you that you have the right to physically be present in the courtroom?
Yes, ma'am.
Do you waive the right to be physically present in the courtroom?
Yes, ma'am.
And do you waive your original signature on the indictment to authorize the court to sign the indictment on your behalf?
Yes, ma'am.
All right. Okay, so Mr. Jones, what is your true, correct, and legal name?
Tavares Jones.
All right. At this time, are you taking or under the influence of any alcohol, drugs, or medication?
No, ma'am.
How old are you?
33.
How far did you go in school?
I got my GED.
All right, good. Are you able to read, write, and understand the English language?
Yes, ma'am.
All right. Do you understand that you are charged with count one, armed robbery, count two, possession of a firearm or knife during the commission of a felony, count three, theft by receiving stolen property, count four, possession of a firearm by a convicted felon, count five, possession of a firearm by a convicted felon, and count six, obstruction of a law enforcement officer?
Yes, ma'am.
Do you understand that you have the right to either plead guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial.
Yes, ma'am.
Do you have, well, And so have you looked at the waiver of rights with your form with your attorney? Or have you discussed your waiver of rights?
Yes, ma'am.
Okay. All right. Have you had enough time to speak with your attorney, Cody Young, about all of the facts and circumstances known to you regarding the charges in this indictment, including any potential defenses?
Yes, ma'am.
Okay. Do you need any more time to discuss the case with your lawyer?
Yes, ma'am.
You need some more time to talk to him?
Yeah, I just want to ask him a question. Is it okay?
Yes,
Your Honor, if we could have a breakout room, I anticipate this being very short.
all right, can you do that, Ms. Woods?
And Smith State, right?
Yep. I still see the defendant. No, he's gone. Do they come back on their own
Yeah, they can leave on their own.
and then come back?
Can I send a message to them?
Your Honor, I am back. We should be having Mr. Jones join us very shortly. Thank you.
Thank you. All right, you may proceed, Ms. Maxwell, please.
Judge, she needs to unmute.
Sir, you need to unmute.
Sorry,
There.
sorry, sir. Thank
I
you.
mean, wait a minute. Okay, we good. Okay.
All
Right.
right. Mr. Jones, are you satisfied with your attorney's services?
Yes, ma'am.
All right. Do you waive the formal reading of the indictment?
Yes, ma'am.
All right. Do you waive any and all defects in the indictment?
Yes, ma'am.
Has your attorney advised you that the maximum sentence for the charges in this indictment is 41 years? The
Yes, ma'am.
maximum.
Yes, ma'am.
Okay. Do you understand that this is a negotiated plea, which means that the state will recommend to the court the following sentence? On count 1, armed robbery, 20 to serve 15. Count 2, possession of a firearm during the commission of a felony, 5 years consecutive to count 1 suspended. Count 3, theft by receiving stolen property, 5 years concurrent to count 1. Count 4, possession of a firearm by a convicted felon, 5 years consecutive to count 2 suspended. Count 5, possession of a firearm by a convicted felon, merge with count 4. Count 6, obstruction of a law enforcement officer, 12 months concurrent with count 1 suspended.
Yeah, ma'am.
We are also recommending the sentence be backdated to January 5th, 2015, and you receive credit for time served. You understand that?
Yeah, ma'am.
Do you understand that the court does not have to accept this recommendation? The court can sentence you to the maximum of these charges. Do you understand that?
Yeah, ma'am.
Okay. Do you understand that this plea may be used in the future to enhance sentencing on any other conviction?
Ms. Maxwell, sorry for interrupting you.
Yes,
Ms.
sir.
Woods is pointing out to me on that indictment, he's charged with count 1 armed robbery, count 2 possession of a firearm during commission of a felony, 3 theft by receiving stolen property, 5 possession of a firearm by a convicted felon, and 6 misdemeanor obstruction, not count 4.
I am so sorry, Your Honor. I made that mistake. So
Okay.
let me go back over the charge. Okay, so it would be count 1, armed robbery, 20 to serve 15. Count 2, possession of a firearm during the commission of a felony, 5 consecutive to count 1, suspended. Count 3, theft by receiving stolen property, 5 years concurrent to count 1. Count 4, dismissed. Count 5, possession of a firearm by a convicted felon, 5 years consecutive to count 2, suspended. And count 6, obstruction of a law enforcement officer, 12 months concurrent with count 1, suspended.
Now, wait a minute, Ms. Woods is shaking her hand. I think she just says it doesn't apply.
Right.
I don't think you dismiss it. I think you just say it doesn't apply.
Doesn't apply. I'm sorry,
Okay.
count 5 does not apply.
4.
Four.
Count 4. I don't know what's wrong with me today. I apologize.
Count 4. We're all doing fine. Everybody's good. Count 4 doesn't apply to this defendant. It applies to the co-defendant.
Not apply. I don't know why I missed that. I'm so sorry. Does not apply. All right.
You can't get anything by Judge Woods.
That's excellent. I appreciate that. Thank you so much.
For future reference.
The court does not have to accept this recommendation. You understand that, correct?
Yeah, ma'am.
All right. Do you understand this plea may be used to enhance sentencing on other convictions in this jurisdiction, as well as in other jurisdictions, including federal court?
Yeah, ma'am.
Okay. Do you understand that if you are not a U.S. citizen, a guilty plea conviction will affect your immigration status or will result in deportation?
Yes, ma'am.
Okay. Do you understand that neither the court, your attorney, nor the district attorney's office has anything to do with parole, the Department of Corrections, or the Board of Pardons and Paroles? And no one can guarantee you parole no matter what you've been told. Do you understand that?
Yes, ma'am.
Okay. Do you understand that you waived any and all defenses, including mental health defenses, by entering this guilty plea?
Yeah, ma'am.
Okay. Do you understand that by pleading guilty, you are giving up the following rights? The right to a trial by jury. Do you understand that?
Yes.
Okay. The right to remain silent and not incriminate yourself.
Yes.
Okay. The right to confront witnesses against you.
Yes, ma'am.
Am I frozen?
You are
Am I
frozen. Not anymore.
Okay. All right. Sorry, Your Honor.
That's
The
fine.
right to assistance of counsel hired by you or your court-appointed counsel if you cannot afford an attorney.
Yes, ma'am.
Okay. The right to the presumption of innocence.
Yes, ma'am.
The right to testify on your own behalf and present other evidence.
Yes.
The right to subpoena witnesses and compel production of evidence.
Yeah, ma'am.
The right to have the charges against you proved beyond a reasonable doubt.
Yes.
and the right to appeal if you were convicted of these charges.
Yeah, ma'am.
Okay. Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No, ma'am.
All right. Are you entering a guilty plea because you are in fact guilty?
Yes, ma'am.
All right. How do you plead to indictment number 14 SC 124061? Count 1, armed robbery. Count 2, possession of a firearm during commission of a felony. Count 3, theft by receiving stolen property. Count 5, possession of a firearm by a convicted felon. And count 6, obstruction of a law enforcement officer.
Guilty.
How do you plead?
I plead guilty.
Okay. Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
I didn't understand what you said. Said it. Can you say that
Sorry.
again?
Okay. Do you understand? Wait. Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Oh, yes, ma'am.
Okay. Do you understand that you have only a limited right to appeal this guilty plea conviction?
Yes, ma'am.
Do you understand that you only have 4 years from today to file a habeas corpus petition?
Yeah, ma'am.
Okay. Your Honor, if this case had gone to trial, the state would expect to prove beyond a reasonable doubt that on October 30th, 2013, Mr. Jones and Joseph Epps went into a Cash America pawn at 2380 Jonesboro Road in Atlanta in Fulton County. The two men were armed and demanded cash. They took jewelry from a display case as well as cash from the register and safe. The men then fled the location. The Cash America employee who put the jewelry into the bag also placed a GPS tracker in the bag. The bag tracked the bag to the tracker came back to Mr. Epps' parents' home. When the officers arrived, Jones, Epps, and a third co-defendant fled but were quickly caught. No one was injured during this armed robbery. Mr. Epps also pled guilty and was sentenced to 20 to do 12. The state and the defense have agreed to a joint sentence recommendation of count 1, armed robbery, 20 to serve 15. Count 2, possession of a firearm during the commission of a felony, 5 years consecutive to count 1, suspended. Count 3, theft by receiving stolen property, 5 years concurrent to count 1. Count 5, possession of a firearm by a convicted felon, 5 years concurrent to count 1. And count 6, obstruction of a law enforcement officer, 12 months concurrent to count 1, suspended. We are also asking that this be backdated to the non-protunct the sentencing order to January 5th, 2015, and that you be given credit for time served from December 30th, 2013.
Sir, do you understand the nature of the charges against you?
Yes, sir.
You understand all the rights you're giving up here today?
Yes, sir.
And you're giving up all those rights freely and voluntarily and intelligently?
Yes, sir.
And you're pleading guilty freely, voluntarily, and intelligently to all the charges?
Yes, sir.
Are you satisfied with the services of your counsel, Mr. Young?
Yes, sir.
Mr. Young, are you satisfied that your client is competent and entering this plea freely and voluntarily, and that there is a factual basis?
I am, Your Honor.
I find the defendant's competent to enter the plea. I find the plea has been entered freely and voluntarily. I find that there is a factual basis. I will accept the plea and sentence as enunciated by Ms. Maxwell for the state and agreed to by Mr. Young for the defense in the negotiated plea. The credit date of the December date in 13 will be given. The plea will be non-protunct to the stated date in 2015. And we have signed the order.
In the new order, but if Ms. Maxwell could please confirm the date, because the dates that we have on the order that was emailed to us was December the 31st, not the 30th, and January the 6th, not the 5th.
Now you're on mute, Ms. Maxwell.
trying to be good. I have December 30th, 2013 as the date for his time served. And let me confirm the date of the final disposition. It was January 5th, 2015.
Well, those dates will be the operable dates.
Yeah.
Okay, good luck to you, sir. Thank you, counsel.
Thank
Okay.
you, Your Honor.
And then they conclude Zoom. We have one more to do in person. Y'all are all excused. Thank you.
Thank you, Judge.
Thank you, Mr. Young.
You're excused. Yes, sir.
Okay.
All right, do we have a plea, Mr. Atkins, in court?
Yes, Your Honor, we do. This is going to be a non-negotiated plea, and the state's ready to proceed.
The state's recommendation is 5 to serve 3.
Yes, Your Honor, and that would be also with